And we say we're not the standard case. The fourth point I want to make...
Should we just, as we're looking at it, look at paragraph 54?
Yes.
The last sentence. The question is whether the court should exercise its discretion to refuse to proceed, as the judge did, and then these words, or to grant relief under judicial review at a substantive hearing according to the established principle, so forth. And then paragraph 55, second sentence, it's a matter of discretion for the court where it is clear that a public authority is acting in defiance of the rule of law. Yes. The High Court will be prepared to exercise its jurisdiction without waiting for anyone else. And lastly, perhaps at paragraph 58, in the parenthesis about 8 lines down, a quotation from Lord Templeman.
Yes.
Judicial review process should not be allowed to supplant normal appeal unless the circumstances are exceptional and involve an abuse of power of a serious character.
Yes.
So it might be that those aren't envisaging a firm bar.
Indeed.
They are envisaging an evaluative exercise about what the impact on the particular case should be of the alternative remedy principle.
Indeed, my Lord. Thank you. So I emphasise Parliament clear, but also standard case. In the standard case, I'll explain why we said we're not the standard case. The fourth point I wanted to make is by reference to paragraph 56, where the context is set out. The basic object of the tax regime is to ensure that tax is properly collected when it's due and the taxpayer is not otherwise obliged to pay. The appeal is more effective, and also, importantly, the lawfulness of HMRC's approach is, quote, not of central concern. That isn't the case here. As my lady observed, we have ground 8. I'm sorry that we refer to it as a failure to consult.
I probably used the wrong
word. No, it's not your fault, if I may say so. In our skeleton, we've referred to it as a failure to consult. It's a failure to consult the claimant. It's classic due process. It's classic, we say Bank Melat, they say Begum, if you'll remember the case. So it's classic due process, absolutely central, failure of natural justice, absolutely classic nullity JR territory. Nothing to do with post-proscription events at all. Extraordinary, if I may say so. So extraordinary, slightly surprising.
Could it be raised as a ground for applying for deprescription?
Well, look, Lord Justice Richard says that you could get round it, but it's. I think Mr. Emerson had said, well, the Secretary of State might not engage with that because it's historic, and Lord Justice Richard said, well, that's unlikely. But if there's doubt in it's circuitous, why get into all that? But the point is that negatives the idea.
We could make that clear. I mean, if it's right that it's the statutory procedure, and if it does govern this, or could govern this, reach that conclusion. So the fact that it is capable of being judicial review doesn't answer the question if, in fact, it's also capable of being dealt with on an application.
Yes, but do you remember the point? Sorry, my lord. But you remember the point that you made? Differentiate between grounds and the decision. Or sorry, it was my lady who made the point. That decision is not up for grabs.
That I understand. Yes. But you're seen to be
There's
saying...
a mechanism by which, yes, you could, according to Lord Justice Richard, Mr. Justice Richards, as he was, that you could get to that. Yeah. But the reason I'm raising that is to negative the idea that we're simply relying on post-prescription events. We're not in the slightest. And to differentiate our position from that which obtained in Glencore, where it was said, as a matter of context and statutory construction, the lawfulness of the historic approach wasn't of central concern. Paragraph 50, this fifth point I want to make, is that there was a review period in that case, in the taxation context, where the parties were supposed to discuss the tax due, and we see from paragraph 67 and 70 that was basically akin to mediation. It was supposed to, the objective of it was, as a matter of construction, to enable the parties to clarify each other's case. It's a very different context to the one that we've got here. That's all I want to say about Glencore. Preston, I don't want to take you to, obviously it's relied upon. There's quite a trenchant and amusing discussion of Preston in Wade. I'll just give you the references, if I may. Wade is tab 51, Second Authorities Bundle, page 1397. And it's a general discussion about how the different trends in the authorities. One of the things the authors say, 1399, in reality the courts are better than their word. There you go. We've cited my lord. We've cited my lord's book.
Professor Wade, has it happened?
Sorry?
Who disagreed with Professor Wade, yes.
So we cited my lord, and you said, my lord, this is tab 49, page 1342. You said, different formulations and understandings of the rule can be seen in the case notes. Of course, we accept that. One recurring issue is the adequacy of the alternative remedy as a means of resolving the complaint. And then you said, these issues can be seen as defining the scope of the principle or as exceptions to the rule. We don't take issue with that so long as we don't have some burden of exceptionality. The key thing we say is that the court should examine adequacy for itself, unless the context, the statute, or a provision or some other rule displaces that, respecting Parliament by looking at the statutory provisions, considering how they apply on the facts, and concluding whether the statutory remedy is adequate. Exceptionality. If we need to show exceptionality, we can. We did argue that below, contrary to what Sir James says in his skeleton. I've checked the notes, according to my memory, I absolutely did argue it below. And we deal with it in our skeleton at paragraph 15. And 3 short points on the facts. 1 point about exceptionality as a matter of law. The issue of law, you won't be surprised to learn, is that we say there is a colossal remedial deficiency here for the reasons the court will be aware of, and the further 2 points that I made. In terms of the facts, just 3 short points. First time ever, direct action organisation does not advocate for violence, has been proscribed in our history. Second short point, very considerable popular support for it. The evidence is that before proscription, Palestine Action had 248,000 followers on X and 413,000 followers on Instagram. Supplementary bundle, tab 9, page 91. That's my client's second statement, paragraph 13. As the judge said in his interim remedy judgment, on the basis of the evidence then before him, the day we troubled you, this is an interim remedy, para 13, tab 53, page 1406. The evidence as of then shows Palestine Action has widespread support amongst those supporting Palestine rights, claims that the proposed proscription has given rise to serious concern on the part of journalists, politicians, mainstream civil society, and NGOs. Third short point, proscription has produced what I hope it is fair to say is widespread and ongoing civil disobedience, of which we have, in Lord Hoffman's words, quote, an honourable history. That's Crown against Margaret Jones. And he cites the suffragettes' anti-apartheid movement, which indeed, as my client said, she was inspired by. Jones, it's paragraph 89, tab 22, page 406. And therefore, in a real sense, I hope it is fair to say, there is an issue, a colossal public interest and an issue of public confidence in the regime of the Act. Again, as the judge below predicted there may be. Again, in the interim remedy judgment, interim relief judgment, paragraph 53, the exercise of the power, he said, in respect of a group such as Palestine Action may also have wider consequences for public confidence in the regime of the Act. This is sui generis, non-standard, highly exceptional on the facts, exceptional as a matter of law as well. For all those reasons, no error. And then, my lady, just moving to the factors which the judge considered. This is our skeleton at 16.
Yes.
He was required to determine, as a matter of discretion, in the circumstances, in the round, whether the alternative remedy was. He exercised that discretion with the care, we say, reviewing the evidence, identifying the relevant factors, concluded as he did. We say, we've cited Piglovsky, you'll be well aware of that. You should be slow to disturb that conclusion. Had the advantages of a trial court. Indeed, he twice says that he couldn't summarise all the evidence. That's the judgment below at paragraph 10 and the interim relief judgment at paragraph 17, which he borrowed from in his judgment below. No error in his assessment, entitled, indeed correct, though I don't need to say that, to come to the conclusion that he did. First factor is timing. Sir James asserts 3 flaws in his skeleton at 35. The judge looked at this at 34 and 35. The first criticism is, well, JR is always going to be faster and it's going to make the statutory procedure a dead letter. It's totally meritless criticism, we say, our skeleton at 20. The judge did not regard timing as sufficient on his own. He said in terms at 33 that he was going to look at the factors cumulatively. He said in terms at 36 that, as Glencore shows, whether a later alternative remedy is suitable depends on the nature of the detriment and whether there's an effective remedy for it. Second flaw, that Parliament's introduced a step of 90 days. That reflects the deliberate intention to afford primacy to the Home Secretary in this area. You have the Alsatia submission. The 90-day period is the Home Secretary's period. It's not Parliament's. Constitutionally, the order is hers. Parliament just has a veto power. If you look at Smedley, that's how it is put there. And it was in any event open to the judge to have regard to the impact of the delay in the circumstances of the case, which are on any view non-standard. The third asserted flaw, the judge's finding as to timescales, was unevidenced and wrong. We say at our paragraph 21, Roman 2 of our skeleton, he was entitled to reach this conclusion. Secretary of State was asked to expedite, failed to undertake to do so. No evidence was put in by the Secretary of State. She's a repeat player, as it were, in POAC, and the point was expressly canvassed in oral argument and put in issue in our skeleton below. That's core bundle, tab 16, page 193. Para 74, Roman 4D. Sorry about that. So the points on timing are without merit. Then detriment and remediability, judge at 37 to 44. Secretary of State makes the following criticisms. Firstly, in her skeleton at 36, and Sir James today, that detriment just reflects the reality of the prescription. And so the point only concerns timing. That's, with great respect, hopeless. The judge considered at 37 to 38 how, not just whether there would be a detriment, obviously that's inherent in the scheme, but the nature of it and its extent as well. If you look at him at 66, the judge at 66, he differentiates this case with KWP on the basis there have been so many, as he said, there have already a large number of criminal proceedings for offences in relation to Palestine Action. And then he looks at the issue whether POAC could repair it. He also said at 37, he was right to say, entitled to say, observing the chilling effect on the legitimate political speech of many thousands of people on an issue of considerable importance to them and to the country as a whole, would do considerable harm to the public interest, decision requiring Secretary of State to lay an order could not repair the injury in the way that a payment of interest could in Glencore. Of course, the High Court doesn't have a time machine, but the point is that just here, justice delayed is very much justice denied. Time is of the essence. Secretary of State then says at paragraph 37 that the proscription would have no legal effect on the peaceful activities of members or supporters of Palestine Action. save that they couldn't engage in conduct contrary to the Act. But we say that's a bad point, seriously bad point, because sections 11 to 13, which are cited, as well as the suite of other provisions in the Terrorism Act, apply to peaceful activity, otherwise lawful peaceful activity, and have had and continue to have a colossal impact on supporters. Over 1,500 people have been arrested for peaceful display of support. Palestine Action was always much more than simply a direct action group. C. Feinstein, an expert on arms who served in the ANC under Mr. Mandela, supplementary bundle 8, page 84, para 11, referring to demonstrations, banners, protests. As Volker Turk, the UN High Commissioner for Human Rights himself has said in relation to this proscription, the decision to proscribe limits the rights of many people involved with and supportive of Palestine Action who have not themselves engaged in any underlying activity, but rather exercise their rights to freedom of expression, peaceful assembly and association. That supplementary bundle 24 at page 217, Volker Turk. I think your ladyship ruled in Sati that was in the context of Just Stop Oil, that you could have a criminal provision which absolutely applies to peaceful expressions of protest and therefore engages Article 10. So the idea that this has got no impact on the peaceful and otherwise lawful activities of Palestine Action supporters is really difficult to understand. Sir James relies on the Arumungam case. That's totally misplaced because the Secretary fails to understand that the appellants in that case were not the members of the proscribed group. They were affected by it, but they weren't the members. In her submission, Sir James also says that as regards the judge's first category of people, this is the judge at 40 to 41, Sir James's skeleton 39 to 40, this is the over-policing category. So the people who are not on any view expressing support for Palestine Action, but just Palestine more generally. Secretary of State says that's irrelevant, again by reference to the same case, that's at her skeleton 39 to 40. Again, with respect, a thoroughly bad point. Whether or not POAC were correct, they were directing themselves to the proportionality of the prescription, not whether JR should run. It's obviously relevant to that question, whether JR should run, that, as the judge put it, an indirect consequence of the proscription is that people who on no view express support for Palestine Action are being questioned and arrested. As we say in our skeleton at 26.1, the judge here conducted a nuanced and valid evaluation of the evidence. See the judge at 41. It's important not to draw too much from this, but it's liable to have a chilling effect on those willing to express political views. We, of course, contest Aramagan. We don't accept that it's correct for a moment, because you've got to look at the practical impact of the measure, not its operation in theory. From a Strasbourg perspective, police are state agents in any event. The submission advanced by Sir James today and in his skeleton at paragraph 41 is concerning. This is an attack on the judge's approach to two categories. The second category, the grey line category, and then the people who are deliberately falling foul of the criminal law. Sir James says that the judge erred in allocating any weight at all to these two categories on the basis that those people in those categories are deliberately sowing confusion or cynically adopting a litigation strategy to inundate the courts. The judge, as regards the third category, deliberately flouting the law, that was the issue before you, if you remember, in the grounds of appeal, one of the issues, he refused to allocate significant weight to the people in that category. We addressed this at our skeleton 26, Roman 2 to Roman 4, As to category 2, the grey line category, no evidence at all that those individuals were deliberately sowing confusion. The judge was entitled and right to say that the existence, this is paragraph 41, I think, sorry, yeah, thank you, that the existence of a large category of cases that are close to the line demonstrates that the prescription is likely to have a significant deterrent effect on legitimate speech. Second, as to category 3, even if the judge was right to allocate limited weight to that category, those individuals have, the point I was making earlier, Article 10 rights, peacefully expressing support, that are likely, on any view, to be restricted through the chilling effect of the prescription. And then the other point we would make is anything there was an undercount there because the judge didn't account for perhaps the largest category of affected persons, those who might support Palestine Action, but whose speech has simply been silenced. And that previously popular speech is protected by the Convention for the reasons I said and is now prohibited.
I'm just trying to try this. Nobody's arguing that you can't challenge it.
Sorry?
I said I'm trying to work out how these work fit into the principle. Nobody's suggesting you can't challenge this order. The only question is where. And is your point that all these things are important things
Yes.
and the POAC is going to be taking too much longer?
Yes.
Or is this...
I'm on timing, detriment, remediability, the judge's first two factors. And I'm about to address you. This is just supporting what the judge did. He looked at all these things in the round, cumulatively, quote unquote, paragraph 33. And so James is saying there was some sort of error in there. We say absolutely not. But the judge said these gave rise to powerful reasons why time was of the essence. And then the point about remediability I wanted to make is a rather obvious one, that interference with Article 10 rights, either through the chilling effect of state action or through police measures, are very serious, both through the prism of the common law, see the Derbyshire City Council case, no right for defamation, because the common law set a prior standard. In that case, the argument that free speech should simply, as a common law right, should simply be a defence was rejected. Defamation, if you remember, just wasn't available. It's a very strong case. And also of Article 10. And we've cited a Russian case, Novaya Gazeta, and that's in the authorities at 47, page 1195. I'll just give you a reference to paragraphs 106 to 1110, pages 1220 to 1221. One of the essential foundations of a democratic society, of course, extends to speech that offends, shocks, disturbs. Little scope for restrictions on political speech, even harsh criticism of the government, caustic language to protect it, doesn't incite to violence or hatred. Even small informed campaigns groups must be able to carry on their activities effectively. And the reason the case is important is that was, I think, one of a number of cases, certainly another case called Ecosystems, where the Strasbourg court granted Rule 39. We see that from page 12, para 12, page 1126, which indicates that Article 10 interferences have the potential to be regarded as exceptional, irremediable harm. Your lordship's ladyship will know that usually Strasbourg only gives that in Article 2, Article 3 cases. The Russian government in that case was told to abstain from actions and decisions aimed at fully blocking, terminating the activities of the applicant, but in the current circumstances could deprive the applicant of the enjoyment of its rights guaranteed by Article 10. The case was about the shutdown of the applicant media organisations.
What the judge is doing in sections 1 and 2 is saying it's going to be quicker in the High Court. Whether or not that is relevant depends on the nature of the detriment. The nature of the detriment here is the chilling effect on freedom of expression and all the rest of it.
Yeah, which is very serious and not remediable, and it's widespread. Sorry if I'm getting into the weeds.
No, but that is it in a nutshell.
It is.
At a headline. Yes.
Criminal cases, the third factor that the judge looked at, judge at 44 to 49, our primary position is that regardless of whether Bodington applies, and we say absolutely, there is a very strong case that it does. I'll address Wicks in a moment. Regardless of whether it applies, the criminal cases are a compelling reason for the availability of judicial review here. If Bodington is available, then the judge's reasoning applies. But if it's not, then it's absolutely vital that JR is permitted to proceed to protect the rights of the hundreds, if not thousands, of people subject to arrest, criminal proceedings immediately following prescription, where people have been arrested and some have been required to enter pleas. Bodington, it is said in the Secretary of State's skeleton at 42 to 44, there's a lot of, if I may say so, a lot of sound and fury there. The complaint is that the judge regarded Bodington as pivotal. He did no such thing. He said at 44 to 45, sorry, he said at...
45 seems likely as a matter
Seems
of
likely, sorry, my note is right. Seems likely. He basically just said it's likely. But you have the point that we say that the distinction which the Secretary relies upon makes no difference. It's bad in principle and as a matter of precedent. In terms of precedent, in our skeleton at 33, we cite the case of James. Just give you the reference. Authorities 24, page 446, para 39. Public Order Act, Senior Constable has the power to impose a condition, criminal offence for breach of that condition in section 14.5. This is assemblies. You can attack the underlying administrative executive decision. That's James. And then Bodington itself, if I can just ask you to take my skeleton up for the first time, and it's we deal with this 35 to 36.
Yes.
So the quote there, obviously very well known and very powerful authority, and Lord Irvine, we've quoted from Lord Irvine. Lord Irvine's in the majority, apart from what he says about ultra vires, the ultra vires doctrine, second actor and so forth. Nobody agrees with him on that, but everybody else agrees with him on what he says about the availability of the defence. I think it was his first case when he became Lord Chancellor. The quoted passage is at 153H, 154A at page... My references.
Well, you've helpfully quoted it, haven't you?
Yes.
It will be a fundamental departure.
Indeed. Page 233, and then the reference to having looked at Winder, the language of based upon, that's at 157A, page 237, and then 37 in our skeleton, Bodington defence availability turns on the particular context, whether Parliament has ousted it, strong presumption of the defence being available against a construction which would prevent an individual being able to vindicate rights in court proceedings. And so that second bit is at 161D, internally page 241, and the strong presumption is at page 242 of the electronic, and internally 162 letter B. And the limitation on the defence is where administrative acts are specifically directed at the defendants and clear ample opportunity to challenge the legality of those acts. That's the Wicks planning context. Specific act, you've got an opportunity to challenge complex machinery. Nothing like that here. It's, on the face of it, no opportunity to challenge, on the face of it, and not a specific act directed at a particular individual. So Wicks is, with respect to bad point, and it's not a point that Sir James has previously run, and then over the page in our skeleton, the offence is available where, as here, subordinate legislation is promulgated, which is of a general character, and or a general provision is brought into effect by an administrative act, and that is page 161, letters F to G and H, page 241. Precedent completely against this distinction, which is now put, not raised before the judge below, perhaps understandably, looks like something of an afterthought. As a matter of principle, again, the submission is bad on the part of the Secretary of State because, as a matter of general theory, a defect in an earlier executive decision is apt, subject to any contrary statutory provision or contrary rule of law, it's apt to have consequences down the causal chain. As the Supreme Court recognised in the DN Rwanda case. DN Rwanda you have at tab 35, page 710, the Supreme Court there held that an unlawful deportation order upon which the legality of detention depended meant the detention too was unlawful. Never mind that you'd had an appeal which said that, that on the merits which had dismissed, which had not been lost, if it was unlawful, that had effects down the causal chain. It's paragraph 17 to 20, Lord Kerr, pages 722 to 723. Clear analogy here, the offence depends on the legality of the order. False imprisonment is different. I know, I think my Lord's criticised Percy and Hall. In fact, I think, maybe not. In your book, I think you criticised it. But we don't need to get into that. Strong presumption, Bodington would apply here.
Everybody can rush out and buy the book.
Yep.
A slip of £240.
It's a bargain. And then Secretary of State at paragraph 43, inter orum argument, too many cases, it's not a principal basis. See in particular Lord Steyne, if you remember Lord Steyne in Bodington talked about the idea that magistrates' courts having lots of cases was not an idea not to afford the defence. It's a very good idea to have JR once it's up, JR is up and running. So those are my submissions on criminal cases. Section 7, I'm not going to say anything about that. You Lordships, Ladyship, have all the points on that. Forum and procedure, we rely on what the judge said below, paragraphs 50 to 57. You have the point in our skeleton at 46 about Section 7, Human Rights Act. So it has to say there is an implied ouster of Section 7 as regards decisions to proscribe under Section 33A of the Terrorism Act. That is an ambitious and extravagant submission for which there is no proper basis. Implied ouster of fundamental human rights and access to court.
I'm just thinking you wouldn't have been able to make your application for interim relief if it was a prescription thing, would you? Because
We
you
wouldn't
say
have done.
90 days you'd have to wait, and you came that Friday.
Sir James,
Yeah.
Sir James below accepted, I hope I'm fair in saying, but for distinct memory, that availability of interim relief was a reason to have judicial review. Absolutely. Then my submission was, well, that's not a one-off, because we renewed our submission, lost, didn't trouble you that time, on the basis of change of circumstances. But yeah, absolutely, he said that. Your Lordship's right. A point I want to make that's occurred to us, or I should say the formidable Mr Luckhurst who sits behind me, and if it's a good point, it's down to him. If it's wrong, it's completely my fault. It is not at all clear, and it looks as though POAC does not have the power to admit interveners.
Does not have the power to allow interveners.
Yes. And your ladyship will be aware.
We know that intervention's been allowed here.
Yeah, Professor Bensall, UN Special Rapporteur, Amnesty International,
Yeah,
Liberty.
you don't need to list them, but yes.
Sorry. So POAC rules. If you look at POAC rules, Tab 10, page 114.
Yes.
They begin. Rule 5 is parties, page 120. Parties, appellant and secretary of state. You look at Rule 20, which is directions, page 137. Sub 4, subject to Rule 29, that's not material here. The Commission must serve notice of any written decisions on every
Directions
part.
under this rule may, in particular, is it not quite a wide power?
Yes, but yes. And then Rule 33, representation, again, nothing about interveners there. We did consider whether there, in fairness to Sir James, whether there might be an implied power in POAC pursuant to its inherent jurisdiction to control its own processes. But that seems to be excluded because the jurisdiction to control, for POAC to control its processes stems from Rule 20. Rule 20 sub 2 provides that the power to give directions is to be exercised.
It's my fault. What's the costs regime in POAC?
Well, there is a decision on that recently.
Can somebody just
I
give me the
can't
reference?
help
SIAC,
myself.
but it'd be the same for POAC, almost certainly.
Okay, don't worry.
Sorry.
I'm sure we'll be able to work that out for ourselves. I'd be interested.
So 20 sub 2, power to give directions is to be exercised subject to these rules. So there does not appear to be general discretion to admit interveners. Contrast the power, express power to admit interveners in judicial review, CPR 54.17 and Praxis Direction 54.
I read that as saying you can't give a direction if it would be contrary to the rules. There's nothing in the rules that makes it wrong to allow an intervener. And if they thought an intervention would be necessary, it would be surprising if a court or tribunal couldn't allow somebody to make a written or oral intervention, or indeed to receive a witness statement.
I think the way I put it is that there's a doubt. There certainly is an express provision. I see the force of what my Lord's saying, but there's a doubt. I'm not sure it's ever happened in SIAC. POAC, obviously, there are only 2 appeals that they've had. But yeah, Rule 5, parties. An intervener is a party. And shall. The parties to appeals shall be the appellant and the secretary of state. Dead letter, the 5th factor, your ladyship, your lordships have the points. There doesn't render a dead letter. KWP, very quickly, we rely upon what the judge said about Mr Justice Richards' judgment 63 to 67, our skeleton 54 to 56. He was entitled to distinguish it in the circumstances and say it was clearly wrong, ex parte tal. Just some further points. KWP, paragraphs 16 to 21, pages 271 to 2, show how different that case was. If you look at the timing, all 3 organisations either sought deproscription, that was the PMOI and Leshkar Taiba, or judicial review, that was the PKK, either 2 or 3 months after the order came into force on the 29th of March 2001. We say that Mr Justice Richards at 75, fulcrum point in his reasoning was his conclusion that Parliament intended POAC to be a forum of first resort for the determination of claims relating to the lawfulness of prescription. That is not at all plain, and indeed we contest that. The key point, perhaps in terms of distinguishing the KWP case, is at 66. The position could be no different. No criminal proceedings in prospect in that case, hundreds, over 1,000 here. And then remedial defects are response notices, the last thing I wanted to address. Macalinen, I think this is the one time, usually Mr James is very accommodating. I don't think he got to this. Macalinen is at 38, page 855. and paragraph 55, page 854, I think it is. Paragraph 55, the question of whether a claimant has a suitable alternative remedy falls to be addressed by reference to the type of claim the claim has chosen to bring and what relief they've sought. Then paragraph 60, page 857, private prosecution wasn't capable of giving a remedy as extensive as she was seeking in her judicial review claim. So that this was a JR against a regulator, except it wasn't a statutory remedy. The idea was, I think, private prosecution for nuisance and abatement proceedings were suitable. The Northern Ireland Court of Appeal said yes, Supreme Court said no. But the question in principle is important. Look at what the claimant is seeking. And then the point I wanted to make about section 7 is, I don't need you to turn it up, it's very clear that the conditions for section 7 to apply are cumulative. It's not enough that POAC has allowed an appeal. You've also got to have the making of a deproscription order. And POAC, of course, cannot compel that. Let's see the discussion between my Lord Justice Edis and Sir James. And when does POAC make an order? Well, you've got the LTTE case. I think we put it... Sorry? It should be on your desks.
The judgment on relief.
Exactly. So if you look at just two paragraphs, paragraphs 20 and 21, which shows that, as I said to you in opening, my lady, outcome irrationality or no evidence are both necessary and sufficient conditions for POAC to make an order. And we see that from 20, seems to us, halfway through the paragraph, appellant's acceptance approach suggests that section 5.4 remedy is not the default remedy in the scheme. Unusual or an application for JR for a court not only to quash a flawed decision to direct the decision maker how to make the fresh decision. There may be cases where applying JR principles, the Commission might find flaws, which meant that an order was appropriate. Example, no evidence to support a decision to prescribe or decision Wednesbury unreasonable. That suggests that would be sufficient, but then they apply it. So existing case law looks as though it's not only sufficient, but also necessary. We consider strictest account of these flaws, which we found that the decision is essentially correct. We didn't find there was no evidence to support, nor that it was Wednesbury unreasonable. This is not, therefore, a case in which we consider it would be appropriate to make an order under section 5.4. So before you even get to the problem that Parliament has a veto, Lord Justice Edis, you've got this hurdle to cross. That doesn't avail us. We've not said no evidence or outcome irrational. Incredibly high standard. So, the very profound remedial problem, classic situation where applying the worst test, presumptive adequacy, the courts have found that there's an exceptional case. If you take Sir James's submission as an exception, we would still, we say, have a compelling case. For those reasons, we say that this appeal should be dismissed. Is there anything else?
No, thank you very much indeed, Mr Hussain. Are you happy to carry on and hear from Sir James in reply on this?
Oh, you're so kind. Yes, of course.
Yes,
Thank you.
James.
I just wanted to address you on two things. The first thing is a very specific one that I know Lord Justice Edis is interested in. He's raised it a couple of times. And I wanted to, in effect, accept and move from that point. The point, I think, was by reference to paragraphs 54, 55 and 58 of Bencore. And if I've understood it correctly, which I hope I have, it was a point that the principled approach does not involve a firm bar, as you put it, being created by the statutory regime, but requires an evaluation in each case, sometimes potentially at the end of a substantive hearing in relation to JR. And the first thing to say about that is that that approach to it attracts no dispute from us. It is a discretion as all the cases make absolutely clear, it isn't a bar if there is a statutory regime. But, and this is the move on bit, it is a discretion which needs to be governed by the principles that the Supreme Court and others have laid down as to how that discretion should be exercised, including in particular the statements of principle that you see in all of the cases on the issue of direct concern here, namely how do you approach the existence of a detailed prescriptive legislative regime when deciding alternative remedy issues. And the answer to that question in principle that the case law gives is very, very clear, we submit. It is, to summarise, that very considerable respect is to be given to the judgments that Parliament has made about the appropriate process. Or to put it the other way, you need to be extremely cautious before deciding that judicial review can and should supplant or run alongside the existence of that sort of regime. And my learned friend Mr Hussain had, in essence, nothing to say about that or to gainsay those statements of principle, some of which my Lord cited, including from the House of Lords authorities that were referred to in Glencore. The final thing to say in answer to that point that was raised helpfully by my Lord Justice Edis is that you will recall, and I think again you made reference to it, the references in those statements of principle to the standard case or the normal process and what that brings to bear in relation to the principled approach to be applied. Those references, in my respectful submission, are very, very strongly against reliance upon asserted defects in the regime that Parliament has judged to be appropriate, because those are, by definition, instances of the process that Parliament has considered to be appropriate. And I emphasise that point, as the case law, all of it does. That's the reference to exceptionality in contrast to those standard or ordinary cases running through the statutory regime. I emphasise that point because the absolutely key factors relied upon by the judge and relied upon by my learned friend Mr Hussain are all of that ilk. They relate essentially to the delay inherent in having the Secretary of State doing the deprescription thing and the contrast with judicial review of the proscription decision itself, which would then said go quicker. That's a feature of the statutory regime. They relate to criminal offences and the way in which the mandatory overturn, as it were, of a criminal conviction happens. Again, that is clearly and expressly provided for in the legislation. And they relate to what is said to be a remedial defect, which is in essence an attack on the statutory regime because it criticises the decision in the primary legislation that Parliament should be involved, not merely at the beginning of the process in signing off the making of the prescription order in the first place, but at the end of the process if POAC decides that there is a legal defect in it. So all of the key points that are said to justify judicial review essentially found on features that are a clear and express set of requirements laid down in the process that Parliament has considered appropriate. That's the first issue I wanted to confront. The second issue I wanted to confront or revisit is the question that was put to me right at the outset and was a subject of discussion when I was making my submissions, which is, how do we know, or is it integral or implicit, to use my Lord Justice Lewis's words, in this statutory regime that POAC should be the thing?
Yeah.
And my
But more accurately, that what Parliament intended was a situation where you have prescription, and then the appropriate way normally, according to you, to challenge it is by to apply for deprescription and appeal a refusal.
That's exactly the issue I'm addressing. And one of the matters that I know concern my Lord, and I gave my answer so I can just remind you of it rather than repeating it, is that the regime was set up in in both section 4 and in section 5.2 in language that is may rather than must. And there isn't an express provision that says this is the thing we normally expect you to do, or you have to go down this route. There isn't anything of that kind. There is simply a may. And my answer to that, as you will recall, is that it couldn't be a must, at least in part, because it's not forcing someone to go down that route. They may decide they don't want to challenge it at all. What the may does is, in Hofeldian terms, to create a right. It creates a right in an individual who is affected or in the organisation that is put on the schedule to go. That's why the language of may is in there. So you can't imply into that non-mandatory language, as it were, something broader. So that's what we say about the first point. But we do submit, with respect, that it is clear from the way in which Parliament has gone about setting up the regime that this is the anticipated route. The appeal route is, of course, available. The route that says, ask the Secretary of State to review with an appeal right attached, which is an appeal from that deprescription decision. Parliament has set that up, so that route is available, but that is anticipated, we respectfully submit, is evident from the detail of the regime that is set up, from the careful consideration of what the procedure should be and should look like, both at the stage of the Secretary of State and at the stage of POAC. So lots of detail about the prescription and lots of consideration about the consequences, criminal and otherwise, of the various stages of that contemplated regime. So it isn't just, as it were, a short permissive option. It is a whole design. It's the design of a multi-stage process with multiple legal consequences built into it, indicating very, very careful thought about how the regime should operate and what we respectfully submit Parliament is expecting people to follow if they are affected by this regime. There is also, we do submit, a timing point that might need to be thought about, which is a point I meant to raise in opening and should have done, but it will have occurred to you anyway, I'm sure. The relevant legislation is in 2000. It was part of a suite of legislation, as I'm sure members of the court will recall, that was introduced pretty shortly after the 1998 Human Rights Act became enforceable and was commenced in relevant part. And this was one of the suite of things that was set up to deal with what were anticipated to be the possibility of convention challenges across a range of things and matters to do with national security that were going to be the subject of increasing challenge, no doubt Parliament thought. So it was introduced in 2000. At the stage it was introduced, the Justice and Security Act 2013, as the date suggests, it was not even a glimmer in someone's eye. And so in 2000, when Parliament was enacting this regime, with all of the careful permission to set up a closed process, with all of the things that you saw in Schedule 3, with all of the enabling provisions, enabling rules to be made that will give effect to closed processes and enable a wide range of public interest material to be considered rather than to be excluded under a PII regime. At the time the Act was passed, there was nothing by way of statutory or legislative permission to have any hearing of that kind at all. Indeed, the only recognised mechanism in 2000 when this Act was set up was PII, which, as you know, is an exclusionary principle, not a principle, indeed the obverse of a principle that would enable a commission or a court to consider material bearing on a decision. Now, you could do, and is perfectly acceptable, I make no criticism of it, you could in those days, and forgetting about the theory of the common law, you could do a Mr Justice Stephen Richards thing. And you could say, well, you know, you could devise something possibly, and indeed some of us remember trying to devise certain things in advance of Al-Rawi telling us that we couldn't actually do that, and that was over-imaginative in terms of what the common law would permit. But at the very least, there would, and the working assumption has to be that there would in the mind of Parliament have been, the gravest doubt about whether certain material which was likely to be absolutely critical to the decision-making on any challenge could actually be advanced in a judicial review. They didn't exclude it, but that feature, I respectfully submit, is very, very persuasive if you are addressing the question, did Parliament expect that people challenging this regime would go down the statutory route which Parliament had provided for with such care and in such detail? There was the real possibility that the challenge, if it was to be JR, simply couldn't consider any of that. And I do respectfully submit that that's a very powerful factor. So for all of those reasons, we submit that the answer to the question, the fundamental question that my Lord posed to me at the beginning, it is a resounding yes, Parliament did expect to go there. I emphasise again, they did not oust, there was a discretion, and there remains a discretion. But this is the usual process. This is the result of first instance, in Mr Justice Stephen Richards' words. This is the way in which applying those principles from Glencore, this is the way that Parliament expects people to go, unless there is a really compelling reason for JR to cut in. And the difficulty, as I indicated a while back, the difficulty with relying upon the sort of features which the judge relied upon and my learned friend relies upon, is that if you say, let's rely on those features that are critical of the statutory regime, you undermine it. And the one thing one can say with absolute confidence is that there is no indication whatever that in the 2000 Act, Parliament was thinking, let's let JR run against a proscription decision, and we'll bring in POAC, sometimes, very occasionally, if there's been a material change of circumstance. But there's nothing whatever in the statutory regime to support that. Indeed, on the contrary, if my learned friend is right, it is entirely to be expected that judicial review would rule the roost rather than the other way around. And that cannot have been Parliament's intention, is our submission.
Thank you very much indeed. Now, the second point in particular, I'm not sure was a point of reply.
Just
Mr.
very
Hussain,
quickly.
would you like to
Yes,
respond
2
to it?
points. Firstly, what does a statute mean? Objective question. The court looks at that now, not anachronistically. Second point, when you're looking at alternative remedy, you decide that now, not 25 years ago. Those are my submissions.
Thank you very much indeed. Well, that concludes the appeal. We move to the permission to appeal application, which is yours. Mr. Hussain, would you like a quick break before we embark on that?
I'm fine, unless you'd like.
No, we're fine. Thank you very much indeed. Everybody else? Good.
But thank
Yes.
you. It's very kind of you to offer it to me. So, my lady, I think there are 5 issues.
Me, or is it very dark?
No, I thought you hadn't paid the bill.
Well, I probably haven't. Let me see. Could you email somebody? I haven't. Well, we'll try and remedy that. I suspect it's the question of a switch being flicked and no more than that. It doesn't affect the mood at all, Mr. I hope you can read, though.
No, I'm fine. Thank you very much, my lady.
I mean,
I just lost my
I
note.
could actually stand up and have a look. Yes.
So, my lady, there are 5 issues on our application. Firstly, are we out of time? What's called a jurisdictional bar. And then 4 grounds. I have carriage of the time issue and grounds 5 and 6, which I'll be very quick on. And then my own friend, Miss Nigrali, King's Counsel, will address you on ground 1 and ground 7.
Very good. Thank you.
So the supposed jurisdictional bar we address in our skeleton at 66 to 67. Please could I invite you to cast your eyes on that. The only thing that's not set out there is the definition of an appeal notice in the CPR. So we've quoted the note alongside CPR 52.32b. Perhaps it's easier if I just give you the reference to our skeleton.
Please.
66.1. If you look at that, the question arises, what does an appeal notice mean? An appeal notice just means an appellant's notice or a respondent's notice. Do forgive me if this is obvious to you. Your ladyship and lordship will be looking at this all the time. That's defined in tab 13, page 172 of the bundle CPR 52.1 3F, about 2/3 of the way down. Appeal notice means an appellant's or respondent's notice. So it's very clear that in this present situation where we need to lodge an appeal notice because we're not just a respondent seeking to uphold an order on additional or different grounds, but we're seeking to vary an order, new order, we need to submit an appeal notice. We can do that in our respondent's notice. Indeed, we're told we must do it in the respondent's notice, see Roman 4. The position on judicial review does not, we say, make a difference. It is true that there is no, you can't appeal the grant of permission to appeal, to apply for judicial review, but it doesn't follow that you can't appeal a partial grant on the basis that a partial grant involves a partial refusal. And
what you're trying to do, isn't it, is appeal that part of the order which refused to bring permission to advance certain grounds. So there is no decision that is being appealed. There is the refusal to allow you to bring proceedings on certain grounds. And 52.8 says precisely what is to happen. You can apply for permission where you've been refused permission to apply for judicial review, but you must do so within 7 days. The machinery, whether you put it in one document or another, is another thing.
we don't accept that because we are the fact, because the policy of the CPR, there's nothing express in that provision which requires us to do that. The policy of the CPR is if you've won below partially, you can sit on your win and see if the losing party wants to appeal to the Court of Appeal.
Exactly.
That's the policy.
If you've won, but you haven't even won.
Of course
you
we
haven't
have.
been allowed to enter the race. You've been told you can't have permission to start
of course we've
playing.
we've entered the race on grounds 2 and 8.
And you're not appealing about that.
No, but the order, the order, it's paragraph 5 of Mr Justice Chamberlain's order,
5A.
and it's bifurcated, and we're appealing against the refusal bit of it. And there's nothing wrong with that. It's perfectly orthodox. Why shouldn't we be allowed to do that as a matter of first principle?
You can, but you've got to do it within 7 days.
No.
52.8.
Well, with respect, no. 66 Roman 1 is the complete answer to that.
Yep.
The complete answer. 66 1 of our statute. An application for permission to appeal to the appeal court must be made in the appeal notice. If you're right, Lord Justice Lewis, then that means an appellant's notice. It doesn't mean
Just
that.
pause, it's all happening. Right, there we are. Thank you again.
Go through it again?
There we go. So, thank you. Yes, take your time, as they're saying on this, so that we can all follow it. Yes.
If my Lord Justice Lewis is correct, then appeal notice in the quoted passage at 66.1 would appeal notice would be coterminous with appellant's notice, but it's not. Appeal notice means appellant's or respondent's notice. If there's any doubt about that, well, there isn't any doubt because it's set out in black and white. But also, if you look at the references in parenthesis that we've highlighted or put in bold, see rules 52.12.1. That is appellant's notice, but also 52.13.3. That is the time limit for a respondent's notice. And a respondent's notice. The rules collapsed what used to be the position a long time ago, which was it collapsed the position of a respondent and a cross appellant. and we just became a respondent. But the respondent's notice allows you to do both things. The critical point being that when you are truthfully a cross-appellant, because you're seeking to vary an order, you need permission to appeal. Where do you seek that? You seek it in the respondent's notice. You've got to do that, see Roman 4, where the respondent seeks permission from the appeal court, it must be requested in the respondent's notice. It's totally irrelevant that we haven't actually got, we've simply got permission to apply for judicial review, and it's at the preliminary stage. That's irrelevant.
I mean, you might say, if that is right, it's a complete code. It's a bit difficult to file a respondent's notice within 7 days. You don't even know what the appeal is.
Well, quite. Absolutely. It's absurd in great respect. And the policy is, we've had a partial win. We absolutely did have a partial win, not just on alternative remedy, but on 2 of the grounds. Otherwise, we wouldn't be here.
What's the point about 52.8 then?
That just restricts the time for appealing to 7 days where you've lost. We haven't lost. We've lost in total. No, we partially lost.
Yes,
and
and
we partially won, and we're entitled under the rules to sit on our partial win and work out whether or not Sir James is going to move this court.
I think we can all agree that rules aren't as clear as they might be on all of this. Has there never been a judgment on it? I mean, this must have come.
We looked at it.
Nothing
couldn't find
anywhere.
anything. Yes, but in principle,
Perfectly happy to see a first instance decision on this. Nothing that anybody can find. All right. If you are wrong about this, if you're right, then obviously you're within time.
Yes.
If you're wrong about it, just so that Sir James and whoever's dealing with it on the respondent side on this case, on this application, is aware, I don't think relief from sanctions is the right target at all.
No, it's
because it's not that. Look at 3. It's not a Denton situation because there's no express sanction being imposed. See the notes 3.9.15.1 in the White Book. What would be required from you, I think, subject to anything I hear from St James's side, would be an application for an extension of time. Now, you haven't made any application.
we haven't.
No. Just wanted to check. But Mr James can come back to us on that, but that's the pretty clear situation as I understand it. But you say that 52.8 applies, can only in context logically be read as a reference to an appellant's notice.
Exactly.
And for these purposes, although you are an appellant or proposed appellant, you're an appellant in a respondent's notice, and a respondent's notice doesn't have to be lodged until 7 days, etc., etc.
Indeed.
I'm not saying I agree. But
No, my leader, I know you're not saying that. But if there's any doubt, you exercise that doubt it's to promote access to court, we would say, and access to the appellate court.
Wow.
There's no reason of policy why we should have to.
Well, the reason of policy is that in judicial review we have very tight time limits.
Yes.
Because things have to be dealt with quickly, and one of the policy reasons will be to avoid last-minute disruption. And we know here, if you're granted permission on any additional grounds, there will be significant disruption in the run-up to the hearing that's fixed for the 25th of November.
We take issue with that on the facts,
right.
but we've got expedition. In an ordinary case where you've got a listing in 9 months or so, there wouldn't be. We would respectfully submit, and the need for an expedition is met and provided for by the duty on the appealing party to get their act together quickly, which the Secretary of State did.
Yeah.
She came to court within 7 days. That then allows us to consider our position.
But there's no connection between what the respondent is complaining about, which is a preliminary issue.
No. You're right. So you'd have to lodge your respondent's notice with your point,
Yes.
and then amend it.
Yeah. But
in response to any appellant's notice on additional or further grounds or
Because
something.
the situation here is you have been refused, you have an order refusing permission to apply for judicial review on the relevant grounds. I forget
Yes.
they are 1, 5, 6 and 7. You therefore need to overturn the refusal of permission to apply for judicial review, and that's what 52.8 does. I haven't gone back to the history as to whether you could even have done anything about a refusal before, but you've got to make an application for permission. That's what 52.8 says.
No,
And that's got to be done within 7 days.
I'm sorry, we're not in that territory because respondents, the time limits for a respondent's notice are not subject to 52.8. And your
understand that, but-
construction is to imply a time limit into the time limit for a respondent's notice. That's our point at
If you're looking at
66.
52.12, which I think you are for the time
Sorry?
limit, that's the point I made.
52.12.2.
Yes, that's the point I tried to make.
Yeah, but that's not, that doesn't speak to a respondent. That speaks to an appellant's notice.
Is it 15.13 then, is it?
Sorry, it's 52.13.4.
Yes.
That governs respondent's notice. That is not subject to 52.8. That's the fundamental point. And there's good policy for that.
Yeah, what I'm trying to say, once I've got the right rule, I've got the right rule now. What I was saying at the beginning,
Sorry.
Mr. Hussain, is that there may be a difference, there has historically been a difference between whether you can bring a claim or not, and if you can't bring the claim, you haven't got a claim, and a decision on a claim. And what I'm putting to you is that when you read the code as a whole, 52.8 is dealing with where you've not been given permission and you're expressly given the opportunity of appealing that, but within 7 days. 52.13, if it's the right one, is dealing with a situation where there is a decision on a claim and you're appealing the decision on the claim. And that's why you've got two rules. Otherwise, it's hard to see what the purpose of 52.8 is
Except
for.
look at 52.13.2a. A respondent who is seeking permission to appeal.
From the appeal court.
Yeah. Seeking permission to appeal from. So, right. Anyway, I think
Anyway, we've got
I
it,
found
yes.
a very clear, as it were, expose of how you put it in your written skeleton. And it may just be we've got to work our way through it.
Yes.
It is all in there, isn't it, C4, your analysis of the rules?
Yes, subject to the definition section, which I gave you the reference for.
Yes.
That's right, yes, you've got to go on to 52.13 very anyway.
Yeah.
Has anyone checked the position historically whether you could have appealed against a refusal of permission before you had the first incarnation of 52.8?
I don't think we have, but we will.
Don't worry about it then. I haven't checked it and I've been writing books on it for 30 years, so I wouldn't worry about it.
I'll then move on to grounds 5 and 6.
Yes, we'll just work it out and decide.
What is the additional definition that you...
I can't remember.
That might be shown there.
Was it definition of appeal? Appellant's notice is appellate respondent's notice. It's 172 I've marked.
Thank you.
Mr. Kynaston reminds me that this would not normally come up before this court because Secretary of State wouldn't be able to be an appellant but for the preliminary issue.
Yeah.
Yeah.
When you make that point in your
Yeah.
written skeleton, yes.
So then, can I just move very quickly to grounds 5 and 6?
Yes.
We addressed them in our skeleton at 58 to 59. The fundamental point is that the judge effectively case managed them and said that they didn't add anything. We're not, this application before you does not concern ground 5A, if you like. So it's not about having regard to irrelevant considerations. It's not 84 of the judge.
Well, I think you'd better tell us, if you take us to the grounds and show us directly which parts of the grounds you are seeking permission to apply for.
Could you go to the core bundle, tab, sorry?
The grounds that are amended are in the supplementary bundle. And it certainly would help me if you could say which paragraphs of that He's seeking permission to apply for judicial
Just
review.
marked up the skeleton notes. So it's supplementary bundle tab 30, and it is ground 5 is at page 332,
332.
and the
Sorry,
so page 332.
there are two supplementary bundles.
Are there?
Placement one, that's the one you
I've got the placement one. So, tab 30.
30, page 332. So you see that ground 5 is in two parts.
Yeah, just give me the page number and the paragraph number. I've got the bundle now.
Three.
80H.
Yeah. So we've set out Friends of the Earth and so forth, and you'll see the ground is in two parts.
Sorry, I haven't got to 80H yet.
Page 332.
Yep. Nobody read the bit in the practice direction saying a concise and succinct summary of the grounds, I take it. Anyway, we're on H now,
Sorry.
yeah.
Yes, page 332, 80H, and then submissions you'll see at 81, irrelevant considerations. We're not appealing that.
Right, so can I put a line through 801, 80,
To 82 we are appealing.
right.
The failure to take into account
82.
Friends of the Earth obviously relevant factors, or to undertake assessments necessary to reach a proper decision. And then we've particularised that in Roman 1 onwards.
So it's just paragraph 82 then, is it?
Yes, under ground 5,
Yeah,
and then there's also ground 6,
yeah.
which is at 83, letter A, through to 86. When the judge dealt with that at paragraph 83 to 86. So the relevant paragraph for our purposes is 85, because he deals there with the relevant consideration issue. Ground 5 is bifurcated. It's the second limb that we're interested in. And he said, no point in debating whether the Home Secretary failed probably to address the fact Palestine Action seeks to prevent conduct which many regard as amounting to genocide and all other serious violations of international law, impact on free speech, impact of prescription on direct action, availability of civil injunctions, and so on. All these matters will have to be considered as part of the court's own assessment whether the prescription order was a proportionate restriction on Article 10 and 11 of the Claimant and others. If the court concludes that it was, there's no realistic prospect of the Home Secretary reaching a contrary view. He seems to be saying futility. If it was not, it doesn't matter. We would say that futility is a very high bar, inevitably be the same. This ground concerns, he didn't say the ground wasn't reasonably arguable. This bit of the ground didn't say it wasn't really reasonably arguable. It concerns a process ground. It impacts proportionality, because my lady, my lords will know that when the court looks at proportionality for itself in human rights context, one of the things it does in allocating deference to the executive decision maker is to consider the degree to which, if at all, the decision maker looks at those issues, him or herself. So the ground speaks to process. Article 10 speaks to outcome. See Denby High School, for example. And 86, no good reason to grant permission. So he doesn't say that limb of ground 5 wasn't reasonably arguable.
Did he say anything in the interim relief judgment?
He looked at that at paragraph 8. He said that didn't raise. He couldn't gauge whether there was a serious issue to be tried. That's at 83, interim judgment. He says uphill struggle because of.
Okay, yeah, I've got it.
You got it. And then ground 6. Again, he gives the same approach. Ground 6, paragraph 87. Ground 6. Home Secretary failed to apply a policy. Following disclosure, the basis on which this ground is pursued, no adequate proportionality assessment was taken, given that on her own assessment, only 3 of Palestine's actions, 385 actions, would meet the statutory definition. Answer to this is the same as under ground 5. In circumstances where the court will have to conduct its own assessment of proportionality, nothing to be gained. If prescription was proportionate, nothing would be gained. The difference there, it's more difficult. The difference there is that the court will be conducting ECHR assessment at the date of hearing, whereas the issue of policy adherence, subject to good reason, no good reason not to adhere, is temporally different.
Dealing with ground 6, if you go back to the original ground 6 and the breach of policy, I do understand that there is a heading which says, when will it be proportionate? But what the policy actually says is the Secretary of State must take account of searching matters, and it's a non-exhaustive list. And
Yes.
certainly she's clearly looked at that because she's identified some of the factors in the press release that she made. So this one seems to be a different set of circumstances because it looks as if the ground, even if the judge said, oh, it'll be swept up under proportionality, in fact, if you look at the ground, some people may say it's not arguable anyway. Factors that she's supposed to take into account, she did.
We resist that because we say that there's nothing to show that she conducted a proportionality exercise.
Well, that depends on what the policy says. It's headed, as I say, proportionality, but what it tells the Secretary of State to do is to look at various matters, and she did. And if that's the case, is it arguable?
Non-exhaustively.
Yeah.
In circumstances where many of the matters availed us, in terms of foreign relations, impacts of foreign relations, nature and scale of activity and so forth.
But she's obviously identified those bits of the policy that she thinks are relevant. She can't have overlooked the rest of it. She hasn't relied on them because they don't show that
Well, I think in the Rwanda litigation, my lord, you impose fairly exacting standards on executive decision-making, and we say that wouldn't be appropriate not to do that here.
Okay, right.
Those are my submissions on grounds 5.
Thank you very much indeed. Ms Riley.
My Lady, my Lords, I'll address you first on ground 7 concerning the public sector equality duty, which I'll take quite shortly and then return to ground 1. And for reference, this is at paragraph 72 of the skeleton. Now, Mr Justice Chamberlain determined that the Secretary of State's failure to have express regard to the likely equality impacts on the Palestinian community itself of prescribing Palestine Action did not breach the public sector equality duty. And this is in the judgment at CB tab 8, page 118, paragraph 93. No need to turn it up. But he held that it couldn't reasonably be argued that the decision document, in particular the community impact, which is at tab 25, page 224, again, no need to turn it up. He held that they couldn't be reasonably considered to be deficient for failing to identify the specific impacts on the Palestinian community because they had considered the effect of prescription on first the Muslim community, then a range of smaller communities in the UK, and 3, those who support the Palestinian cause, which he described in any event as a more precise description of the group affected. And we say that none of those is capable of being an answer to ground 7.
It would help me if you could take me to the section 149, and if you could explain, when you say Palestinian community, what protected characteristic you're looking at, and how it is that section 149, which bit of 149 has been breached.
Well, the section I'd be looking at would be race, nationality, ethnic origin. Palestinians are a distinct racial, national and ethnic origin, and if that has already been considered by this court in
So
the
that's
case of
so it's
Turan.
ethnic origin,
Racial group, yes, ethnic origin.
or racial
yes.
group. But isn't it obvious that the Secretary of State was having regard to that because she was banning something that was to do with Gaza? I mean,
My Lord, it's obvious that she should have had regard to that group, but the point is that she did not. She did not have express regard to the impact of the prescription of Palestine Action on the Palestinian community in Britain. And that's not what the court below found. The court below found that there could be, that it couldn't be reasonably argued that the decision was defective, because instead she had regard to the Muslim community, a range of smaller communities in the UK, and those who support the Palestinian cause. And as I said, he described that group as being a more precise description of the group affected.
well, what has she not looked at? She's banned an organisation that she says is connected to terrorism and is connected with action in relation to the people in Gaza who are Palestinians. We'll see for a moment. And she's decided that because of the terrorism that she says is present with this group, action has got to be taken. It's obvious that that is connected to people who support it. It's obvious that...
Well, my Lord, it's obvious that it is connected, and that's why it's so obvious that she should have had regard to the particular impacts on the Palestinian community in Britain, and she simply can't. And that is not what the court below found. The court below didn't find that she did, in fact, have regard to the community. He found that since she had regard to the 3 communities that I have identified, that was sufficient. And that is the decision that we say is defective, because the Muslim community is distinct from the Palestinian community, which comprises people of Christian faith, of other faiths and none. The reference to the range of smaller communities in the UK, and this is no need to turn it up, but it's the 26th of March ministerial submission. The reference is Supplementary Bundle, tab 25, page 228. That considers that prescription may increase anti-government feeling in these communities, but it doesn't assess the equality impacts on those communities, much less on Palestinians as a sub-community within those. It doesn't come close to the obligation to have due regard under the public sector equality duty, which requires a minister to assess the extent, the risk and extent of any adverse impact, and the ways in which such risk may be eliminated before the adoption of a proposed policy, and authority for that is bracking. No need to turn it up, but the reference is tab 23, page 422, paragraph 26.4.
So I'm just looking at 68A of your pleading.
86A.
Yeah, it's each of those 3, is it, that she's broken?
Sorry, paragraph 86.
A of your
plea. I'm trying
amended
to work
statement.
out which bit of the duty, because it's quite a complex duty, you say she's breached.
Well, my Lord, we'll come on to that. So there are 3 limbs to the duty.
Yes.
And the Secretary of State, one of the reasons we say that there has been a breach of the duty is that the Secretary of State only considered the 3rd limb of the duty, which is to foster good relations between members who have different protected characteristics.
Yeah.
And I'll come on to that, but I'm just dealing with the first point, which is that the Secretary of State failed to have regard at all to the particular impacts on the Palestinian community as a community in Britain. And Mr Justice Chamberlain's ruling that in effect, to have regard to those who support the Palestinian cause is sufficient to consider the interests or the impact on Palestinians themselves.
So fail to have regard to the impact on the Palestinian community, and I can, for the words Palestinian community, I must read those whose race or ethnic origins is Palestinian, i.e. they come from...
They come from what is now recognised to be the state of Palestine.
Yeah, but it wasn't at the time, so it's
Well,
from...
they come from the occupied Palestinian territory.
And the West Bank, presumably.
The West Bank, including East Jerusalem and Gaza, and indeed Palestinians, citizens of Israel within Israel, and indeed the
Well,
refugee
hold on, does she have to have regard to people in Israel? I thought she just has to have due regard. The cases say it's looking at due regard to people here.
It's due, but my lord asked me who are Palestinians, and I'm
Yes, but in the context of this duty. So it's people here who are of who originate from the West Bank and/or the Gaza.
Well, my lord, I'm attempting to answer that question. It's people here also who may originate from within the state of Israel, Palestinians who are citizens of Israel, and it may also relate to people who are refugees or descendants from refugees who have been expelled from the Gaza and the West Bank and so who are no longer there.
Originate or have a relevant tie with.
Indeed.
Yeah.
So you say breach of the duty to have due regard to the need to eliminate and advance equality. And your particulars are in your amended statement of grounds, elaborated as you just helpfully have with my Lord Justice Lewis. And you say the judge didn't find it to be unarguable, he simply said there was no ground.
Well, he said it was not reasonably arguable that she hadn't had, that the decision documents were deficient for failing to identify
Sorry, you're quite right, yes.
specific effects
Quite
on the
right.
Palestinian community.
Yes, my fault.
So that's the
Yeah.
group that we're dealing with, actually. And is it 1491 A, B, or C, or all of them?
A, B, and C, and it's simply the failure. So the Secretary of State had to identify the impacted, the protected characteristics that were likely to be impacted by her policy, and the groups who were likely to be impacted, and she failed properly to consider, as a group, the impact on Palestinians, people of Palestinian heritage or Palestinian nationality within Britain.
But you've got to look at the words. It's got nothing to do with eliminating discrimination prohibited under the Act, has it, this thing, this order? It's not really advancing equality of opportunity, giving people the same chance. You've got something that's made a criminal offence, and that's presumably why she's focused on fostering good relations between people who are Palestinians and who are not. How could it possibly be relevant to A and B?
Well, my lord, it can be relevant because obviously the prescription of Palestine Action was going to have significant impacts on equality, on the advancement of equality and or other equality aims within the UK in terms of the impact it would have on people's access to protest, the impact it would have on access to public life in that regard, the impact it might have on people's access to employment or access to education if people were to be determined to be terrorists and to be convicted of a terrorist
Right, so if
offence.
it's B, it's the effect of introducing an order that will criminalise certain action, and those are more likely to be people of Palestinian origin.
Indeed, so it's more likely to impact them both in terms of arrest, but also just in terms of chilling speech, in terms of their sense of place or contribution in British society, in many different respects. But she fundamentally failed even to identify that they were a group likely to be impacted and primarily to be impacted in many respects. And that is, we say, a significant failure.
So are we dealing with A then? It's B and C. Are we dealing with A?
I'll come on to the different. I'll come on to the different limbs shortly, but right now I'm just simply dealing with her failure to identify Palestinians in
Yes.
Britain as a group
Yeah, we've got
who
that
had
point.
protected characteristics. But it just why it is relevant and why it was a breach of the public sector equality duty and why Mr Justice Chamberlain is wrong to say that it was sufficient to consider the impacts on those who advocate for Palestinian rights and to consider that that was sufficient, is that it is self-evident that a group with protected characteristics and those who support them do not have the same interests, and the risk or the impacts are likely to be very different for both. So it would be similar to suggesting, for example, that if you consider the interests of feminists, including male feminists or others who support women, in relation to a policy that's going to significantly impact women, then you've discharged your duty. Of course, you plainly haven't. Ditto, if when assessing a measure that's likely to impact the black community, you only have regard to people who are anti-racist, including white anti-racists or other people who support the black community, you won't have properly considered the impact of the measure on the black community, and to find otherwise is plainly not correct. It's self-evident that the equalities impact of a terrorism conviction, for example, on an 80-year-old white female vicar are likely to be entirely different to the impacts on 20-year-old Palestinian men, whether in terms of how that conviction is perceived by the society, their impacts on education, on employment, etc. Right. And all the more if they're refugees. And this is
So I've just got an eye on the clock, and divide or use the time as you wish. And we've got ground one to go, but I think your side should be finished at this stage by about 1:45. So we have 45 minutes on the other side as well.
Well, my lady, I hadn't expected that particular to take
I know,
so long.
I know.
But just
Well, we
if I
contributed to that. So finish ground 7 as you wish.
If I could commend the Secretary of State or the Court to consider in particular statements by Dr. Amy Shalan, which is a supplementary bundle 12, 122, page 25, which sets out in some detail the particular impacts felt by the Palestinian community in Britain, and ditto the statement of Dr. Salma Daba, a British Palestinian lawyer, her statement is at tab 13, page 198, paragraph 9, and she just describes how deeply fearful... 128, paragraph 9, how deeply fearful the Palestinian she is about the impacts of the prescription of Palestine Action on the Palestinian community, and how very sinister and chilling and authoritarian it feels to the Palestinian community in Britain for a group that is seeking to prevent atrocity crimes against Palestinians to be prescribed, but not groups who employ similar tactics in defence of the environment or in pursuit of other aims. So there's a particular impact on Palestinians as Palestinians in Britain, and we say it must be at least arguable that the prescription of a group called Palestine Action, one of the founders of which, the claimant, Ammori, is of Palestinian heritage, which is concerned with preventing atrocity crimes against Palestinians in the context of an extreme military assault on Palestinian territory, which many experts consider to constitute the intentional destruction of Palestinians as a group. For the Secretary of State to have erased Palestinians as a group from her assessment of the impacts of the prescription must at the least give rise to an arguable ground. And so too must the other failures by the Secretary of State, which are set out in our skeleton argument, but these are the failures even to address the first two limbs of the public equality duty. And there is ample evidence in the materials that are before the court of those impacts. The advice that she received was defective, that she didn't have to have regard to those two limbs, and there's plainly an arguable case under ground 7. Turning then as quickly as I can to ground 1, which is improper purpose, and that is set out at our skeleton at paragraph 60 to 61. And this challenge concern is that the Secretary of State acted for an improper purpose in exercising her discretion to prescribe Palestine Action. And that is because, and as acknowledged by Mr Justice Chamberlain at paragraph 74 of his judgment, and that might be worth turning up, that's at tab 8.
What's your actual complaint? Don't worry about Mr Justice Chamberlain for a moment. What is it that you say is the ground of challenge? The Secretary of State, rightly or wrongly, has decided that this is a group that, in her view, is involved with matters, and I'll use that word neutrally, which fall within the definition. And she's decided, rightly or wrongly, that she's going to prohibit it. What's your actual complaint with that? Why is that an improper purpose?
So our complaint is that the statutory purpose and object of the prescription regime can be determined from looking at the construction of the Act as a whole. And to allow for the Secretary of State to prescribe organisation, its purpose is to permit the Secretary of State to prescribe organisations the conduct of which meets a high level of severity, a high threshold of severity, which is commensurate with the extreme sanctions and other consequences that the prescription regime brings about. And this is at paragraphs 65K and 65Q of the amended statement of facts and grounds, which is at tab 30. And so we say that the discretion under section 3.3a to prescribe groups is limited to the groups for which these serious effects are appropriate and justified. And that is the nub of the argument.
So hold on, 65K did you say?
We set out what we say the aim of the aim of the Act is at paragraph 65K and 65Q. That's not where the whole argument is set out. That's merely where we identify what we say the object and purpose of the Act is and of the prescription regime. And we say that it can be tested by a number of questions that are set out at paragraph 71 of the judgment, which have been replicated in the judgment, which are, for example, whether or not the group advocates violence, whether the vast majority of their actions amount to terrorism, whether they enjoy widespread support, etc., etc. But the nub of the argument is that it is not proper, and it is not a proper. It is to act for an improper purpose for the Secretary of State to extend that draconian prescription regime to groups that do not meet the high level, meet the threshold that would warrant the application of those to them. And it can be tested, for example, by reference to Section 1 of the Terrorism Act, which would, on a strict construction even, allow for the prescription, for example, of doctors, groups of doctors who are protesting pay conditions, insofar as it were to be asserted that them striking or picketing a hospital is capable of endangering the life of patients. It's clearly done for a political purpose. It's done to influence the government. Actions that wide or groups engaged in that kind of conduct are capable of falling within the definition of terrorism, are capable of being concerned in terrorism for the purposes of Section 3 of the Terrorism Act. But that is not the purpose for which the terrorism...
Yeah, but we've got to look at the press release, whatever it was, it's at the end of the core bundle, and she says why she's done it. And the question is whether the things that she says that she's done it for are purposes for which the statutory power is granted. And it looks, on a brief reading through the statement, that the reason why she's done it is because of the things she says.
Well, my lord, I would respectfully say that that's to look at it the other way round. It's to look at what is the nature, look at her assessment of what she says Palestine Action is. A maximum of hundreds of actions, they consider that only 4 are even capable of amounting to terrorism. In the last 12 months, they say none of the actions have amounted to terrorism.
But there's a argument about, is this good or bad? She's given a power in Section 1, power comes later, Section 3, and there's a definition, and she's looked at it and she said, these things, in my view, are what's happening. And it doesn't sound like an improper purpose argument, it sounds like an irrationality argument.
So you've identified what the purpose should be. What's the improper purpose, do you say?
You say the improper purpose is to extend that prescription regime to groups, direct action protest groups, such as Palestine Action, which are not the same as the activity of which does not meet a high level of severity, and that can be judged by reference to the other groups that are prescribed, which are groups that are Boko Haram, ISIS, Al Qaeda, etc., which are plainly all engaged in a certain level of activity. So that's the nub of the argument. It's not about statutory interpretation.
Yeah, I got it, thanks. Now, it's my fault for being so slow, but I've got it.
Thank you.
Well, I'm 1 minute over the time allocated, so I'll leave my submission.
So you've done ground...
Well, I haven't, my lady, I haven't managed to address all that I wanted to address, but it is set out in some detail, both in our statement of facts and grounds and in our skeleton argument.
Thank you very much indeed. Is there anything that's not there that you consider to be really important that you haven't had a chance to mention?
No, the case is made out on the evidence that is before the court, or the basis of the ground is made out. But I would simply say that Mr Justice Chamberlain made no finding as to whether the claimant's asserted purpose of the prescription regime was reasonably arguable. He made no finding as to whether Palestine Action as an organisation was an organisation which the Secretary of State may prescribe in promotion of the statutory purpose, because of course that is the whole basis of this ground, is that pursuant to Padfield, the Secretary of State can only act in furtherance of the purposes of the statute. Her discretion is fettered in that regard, and it is at least arguable that the Secretary of State acted other than to promote the statutory purposes, and therefore it's at least arguable that the ground is at least arguable.
Thank you very much indeed.
Thank you.
Right, who is batting on your side, Sir James?
It's me again. Sorry about that. The procedural bar, first, if I may. Our suggestion, as you know, is that if the claimant wishes to apply for permission to appeal the refusal of permission on grounds 1, 5, 6 and 7, then an application should have been lodged using, as it were, the permission accorded by the bespoke provision, 52.8, and in particular 52.8.1 and 3.
And what about Mr. Hussein's argument that when you've got a very unusual situation where the appellant, you, are appealing, and he can put in whatever application he wants by a respondent's notice, the time limit is the time limit for the respondent's notice, not the time limit in 52.8.
Well, we say they're dealing with two different things. The only thing that we're appealing from is the interim relief. Is the alternative remedy point.
Yeah.
And so that's the first collapse of substance into form that underpins his argument. And the solution, if he's right, is that you make two separate orders, and then he wouldn't have a prayer. So that can't be right. What the rules have done is to treat a refusal of permission as a distinct category under 82.3, and then to make specific provision for it, including, in particular, the provision that the time limit is strict. And that's a time limit that is strict, reflecting the bespoke nature of the provision, which is judicial review. And that strict 7-day time limit is no doubt based on the fact that the purpose of the permission stage is to provide for an efficient mechanism for determining without undue delay and expense whether the thing is sufficiently arguable to proceed.
But we know that an appeal notice is also a respondent's notice from the definition at the beginning, don't we? So what do we make of 52.13?
Well, my lady, we say that the appropriate solution in the situation he's confronting here would be for him to issue an appellant.
But where the respondent seeks permission from the appeal, it must be requested.
Yes, but that depends on that rather terms and whether he's respondent or appellant on the particular issue.
I see.
Because otherwise, you've got no correlation at all between the thing that is being appealed, here, the alternative remedy.
Yes, I see. So you say on 5A, he's the appellant.
5A
He's
is
the
the
appellant.
appellant. And it dovetails exactly.
On the rest of it, he's
Yes,
a...
what he can't say is, I won a bit. Because otherwise you could have 550 grounds of judicial review.
Yes.
And you went on one of them. Yes. And all the time table goes out
And you
the
could
window.
seek permission to appeal against a bit of the bit on which you won, i.e. the bit on which you were actually a respondent.
Yes,
I
the,
mean,
the respondent's notice is
You
designed
could be a
to
respondent seeking permission to appeal on something where you were actually only a respondent.
Yeah.
And here, if you divide the preliminary, as you say, two orders, then yes.
And that must be the right way of approaching it. The case law, such as it is, we've given you a reference into Brasser Self, paragraph 31 and so on in the bundle behind tab 39. Don't invite you to turn it up. But that must be the right approach, because the emphasis there, unsurprisingly, is that you focus on the substance of it, not the form.
Well, you will have known that other great public law case of Bradbury, which deals with brasseur in the context of judicial review and draws a distinction between that bit of the order where you succeed and that bit of the order where you fail.
Yeah. And it's unsurprising that's the position, because a respondent's notice is by and large an opportunity to say to an appellate court, I want to rely on these additional things.
Yeah.
Whereas if you are actually the appellant, because you're in relevant part you have lost, and you can't say in relevant part I haven't lost because I want another bit of it that's entirely unrelated, i.e. ground 2 and ground 8. It's not as though the door is shut, it's just that it's entirely obvious and you have to treat them as separate, and you are the appellant for that purpose.
But a respondent can appeal on fresh, can do a straight appeal, not just seek to uphold on different or various grounds.
That's the
You have
basic.
to be careful.
And that's how you make the thing coherent. Because otherwise you would have a different set of time limits, depending upon whether you happen to be coincidentally appealing an entirely unrelated point, or, again, entirely coincidentally, you won one ground of permission, but you've been refused on the 440 others.
Well, the other thing is it depends on you appealing. I mean, you may not know until day 13 whether you're going to appeal or not. You may never appeal, in which case there'll never be a respondent's notice. Not only that, you could appeal on day 14, write to them on day 15 and say, we've changed our mind, we're not appealing, before they've got a respondent's notice in. So there may never be a situation where they're a respondent, because there may never be an appeal, or you may withdraw it. And the question is whether 52.8 and 52.13, I think it was, is intended to operate as a kind of happenstance, depending on what happens to you.
Yes, and my only real addition to that, Michael, I totally agree, my only real addition to that is you've got the solution built in if you're looking at the form with which you do this thing. You treat someone who's appealing as though they're an appellant.
Yep.
And then you read 52.12 and 52.13. 13 applies to someone who's genuinely a respondent, and 52.12 applies to someone who's genuinely an appellant. And for that, you have the clearest possible express rule in 82.3.
Yep.
So that's what we say about that. On ground 1, if I can turn to that, our submission is that Mr Justice Chamberlain was correct to find the ground unarguable for reasons which are set out in his judgment, the judgment we've all been looking at 71 to 76. But you'll recall that he, in this respect, when he was considering these grounds, he considered the grounds, as I think had this court, when you were troubled in the evening on interim relief. He considered the grounds already for the purpose of serious issue to be tried. So there is also some useful material which he incorporated by reference, as it were, into this judgment, 71 to 76, in the interim relief judgment, which is in the authorities bundle behind tab 53, 53, page 1419, and the relevant paragraphs for purpose of ground 1, 62 to 69, the interim relief judgment. And the starting point is that the activities of Palestine Action fall within the statutory definition of being concerned in terrorism. That was Mr Justice Chamberlain's conclusion at 64 of the IR judgment, 64 of the IR judgment. See also the 4 points that were made by Mr Justice Chamberlain in that same judgment as to the clarity of the statutory language, as he put it, at 64 to 67 of his IR judgment. And they don't appear now to dispute that the activities actually met that statutory definition. Rather, what they now say, it appears, is the fact that you've done that doesn't necessarily mean that it will be consistent with the statutory purpose. But we do submit that it's absolutely fundamental for this ground of challenge that Palestine Action did meet the statutory criteria for proscription. And we rely on the comprehensive reasons that Mr Justice Chamberlain gave for rejecting this argument at 68 of the IR judgment. I'm not going to go to these bits, given the time. And at 74 of the permission judgment, i.e. the judgment we've been looking at. What appears more specifically now to be said is that the improper purpose argument is based on what is said to be, in effect, a parliamentary intention that even if you meet of the concerned with terrorism definition, you can only impose, and it would be contrary to the intention of Parliament for you to do otherwise, you can only impose a proscription order if the conduct meets, as it's put, a high threshold of severity. And that submission, we respectfully submit, rejected properly as it was by Mr Justice Chamberlain, can't be right. Firstly, the judge clearly has regard to the sanctions and the other consequences of the prescription regime. See the IR judgment 2739, which contains a detailed account of criminal offences. But secondly, and fundamentally, in relation to improper purpose, which I suspect is what prompted my Lord Justice Lewis's question. Secondly, under the relevant legislation, the Secretary of State is not bound to consider whether an organisation's conduct meets a high threshold of severity. That could easily have been provided for in the legislation, and it is not in it. The statutory definition and the statutory precondition is that the organisation should be concerned in terrorism, and we all agree that that test has been met. There is no additional precondition of the kind that would be necessary to found an argument of improper purpose. Now, true it is, no doubt, that some of the force of the point is capable at least of being deployed either as an irrationality argument or as part of a proportionality argument. But it is not an improper purpose argument, because as we know from countless cases, improper purpose depends, as its first port of call, on establishing the nature and intention of Parliament in the relevant legislative regime, and that could not be clearer. If you're concerned in terrorism, there is a discretion to make and there is nothing in the statute to suggest any intention of Parliament to impose that additional hurdle. And my learned friend makes it as a general point of principle, a general argument about the nature of the statutory regime. And we submit, therefore, the judge was right in relation to this.
And there is no allegation, looking at paragraph 74 of the immediate judgment below, of some sort of extraneous purpose, which is why I asked the question I did. So there's no allegation of improper purpose, such as political gain or anything like that. No, no.
I mean, one could see that that would properly found an improper purpose argument.
But that's not alleged.
But it would properly do so because it's got nothing to do with terrorism. That would have everything to do with political advantage. So that's what we say about ground 1. Grounds 5 and 6. Again, we respectfully submit that the judge was right. See in particular the first aspect, that was whether the Secretary of State has taken into account a number of irrelevant considerations.
That's no longer pursued.
That's no longer pursued. And at 84, we respectfully submit as a starting point for that and the end point for that. And so that is clear. And on the second aspect, which is whether or not the Secretary of State properly considered that Palestine Action sought to prevent conduct many regarded as genocide and so on, we found on paragraph 85 of Mr Justice Chamberlain's judgment.
There is a slight problem there. They say that there are certain things which they must mean are mandatory considerations that they must take into account, such that if you fail to take them into account, it's unlawful. And they say the Secretary of State hasn't taken those into account. What Mr Justice Chamberlain is saying in part, he may be saying something more, is, oh, well, we can look at the proportionality of that when we do Article 10 and 11, but what about the straightforward argument that the Secretary of State failed to consider certain identified matters? Are they not mandatory considerations? They're their expressions of views as to why the Secretary of State shouldn't have gone down the route of prescription, notwithstanding the criminal damage, or are they things that she's got to consider, and if she doesn't, she's acting unlawfully if she fails to do so?
Well, although I respectfully submit they're not mandatory considerations, but the judge's reasoning appeared to be, would take this into account as part of whether or not the thing was a proportionate restriction. That's going forward anyway. And if the court concludes that it was, then there's no realistic prospect, even if the Secretary of State took them into account, of her reaching a different view. That appears to be the reasoning in 85, and we respectfully submit that's reasoning that was open to them. And obviously, if it was not, doesn't make any difference. My submission is that is an appropriate way of doing it, and a permissible way of doing it.
But what about a different scenario where the court wouldn't say it was disproportionate in the sense of fails to meet Article 10.2 or 11.2. But if the Secretary of State had looked at these in terms of not will I breach a convention right, is it really appropriate to ban this organisation, given the level of support and what people think about what is happening in Gaza? The Secretary of State might have come to a different conclusion, even though a judge wouldn't categorise that as proportionate or disproportionate.
Well,
It's
my
a
lord,
separate
I think
factor.
My lord, my answer to that, I can found only on the judgment of the learned judge, is that the error, in his view, would not be material in those circumstances if it's taken into account. So he proceeds on the basis that it may have to be taken into account, or could have been taken into account, but he concludes that if otherwise the order was proportionate, then any error of that kind, assuming that error it was, would not be material.
Yeah.
But at least there is some comfort in the idea that this will form part, on his view, of the analysis of proportionality. But what he founds on in relation to that part of it is it wouldn't have made any difference if otherwise the thing was proportionate, and I can understand that. Because then you'd be worrying about terrorism and the thing would have been a proportionate order.
So if the court considers it proportionate, no risk that the Secretary of State would consider it as justifying not making the order because she's already made it.
She's already made it, and
Yeah.
this will go nowhere.
There'd be nothing to put against her current view that this is what is required. Yeah.
So that's what we say about ground 5. Ground 6, we submit that the judge plainly applied the correct test. See the permission decision or the immediate decision at paragraph 88. And in any event, secondly, this ground had narrowed at the time of the permission hearing to whether an adequate proportionality assessment had been undertaken. And it essentially repeated elements of Palestine Action case on ground 2. So he was entitled to reach the conclusion he did in 88, we submit. Nothing to be gained from adding it. The court's going to have to do it itself. It's going to have to look at proportionality. It'll be for the court to do that. So nothing to be added. So we found on that. That's 6. Ground 7. Again, we submit that the judge was entitled in paragraph 93 in particular to reject the criticism. And the prime criticism that appears to be made now is that there was no reference to and no consideration of the positional potential impact on the Palestinian community. And we respectfully submit that there is an obviousness point there, given the nature of the action that was being considered and undertaken. My lord, I know, has recently had to think about these issues in, I think it's in Liberty and EHRC, you were thinking about them relatively recently. But I just wanted to take you anyway back to the documents, if I may.
Yes.
If you go to tab 25 in the supplemental, you will get the document which is the community impact assessment.
Yep.
The relevant bit, I think, or the key bit perhaps, for present purposes, is on page 235. And do you see the 2 paragraphs above section 5, if that makes sense, of other communities, those 2 paragraphs? So we respectfully submit that what the aside from the obviousness point, which is that the direct focus is on the Palestinians anyway, as everyone will have realised, and it's pretty obvious they were considering Palestinian issues because they referred to Palestinian holidays under section 7, first line on page 236. But going back to these paragraphs, these are references to communities which, at the very least, include the Palestinian community. The British Muslim community, the Muslim majority diaspora community, Arab Christians in the UK.
Well, Arab
and
Christians,
so
it's not just Muslims, it's Arab Christians too, which is one of the groups that...
on, which is referred to in the
Yeah.
final paragraph before paragraph 5. So the suggestion that none of this was thought about, none of this was focused on, and the only point really is that the Palestinian community is considered as part of the consideration of potentially broader impacts applying to them but also applying to others. And you get a similar bit of thinking perhaps in the ministerial submission of March if you go forward 2 or 3 tabs to tab 28 and you go to page 267 and look at paragraph 39. Again, you have similar thinking. This isn't restricted to Palestinians, but it is considering the position of the Palestinian group and the sort of impacts that this might have. So we respectfully submit that there is no force in the submission now made order that none of this was even thought about. It was all entirely obvious that it should have been thought about. It was thought about, and the judge so concluded and was entitled to so conclude. So that's what we say about ground 7.
Well, specific community groups, particularly those aligned with the pro-Palestinian causes, PAUSE, and British Muslims.
Yeah.
And then there'd be a fear that the prescription would show a bias towards pro-Israeli causes at the expense of Palestinians. Yeah.
So that's how we suggest in entitlement of the judge to reach the conclusions in paragraph 93 is clear.
And it's again implicit, you would say, I'm sure, in paragraph 41, because when they look at the risk mitigation, it thinks to negative any suggestion that it's anti-Palestine, anti-Gaza, or pro-Israel.
And to some extent, that reinforces the obviousness point.
Yeah. Yep, thank you.
So that's what we say about ground.
Thank you. Mr Hussain and Ms Raleigh.
My lady, my lords, 4 short points, if I may, on the timing issue. First point, the case against us, we say, depends upon regarding paragraphs 2 and paragraphs 5 of the judge's order as 2 separate orders. We're not aware of a judge ever doing that. It may be a fault on our part. But the bigger point is, why would one do that? Why would one construe it that way when that acts so as to create an impediment to accessing court? The second point is that, in truth, we are not an appellant, but a respondent for the purposes of the CPR. In old money, we're a cross-appellant, and a respondent under the CPR can seek permission to appeal, and that is what we've done. The third point, the fact that our case on time depends upon a happenstance in my lord's term of an appellant's notice does make sense for the reasons I gave. We're entitled to sit on our partial win. And the fourth point is I would like to seek an indulgence. We haven't sought an extension of time, but as a matter of discretion, given my lady's comment about the rules not being a model of clarity, I would invite my lady and my lords, as a matter of discretion, to at least allow us through the door on this occasion, given that it's the first case to look at this point, and to consider the grounds on their merit. Grounds 5 and 6, I have nothing to say.
My lady, my lords, 2 points in response on ground 1. The first is simply that an improper purpose need not be extraneous, nor need it be nefarious. And Mr Justice Chamberlain doesn't suggest as much in his ruling. Decision makers may be found to have acted with improper purpose for much more mundane reasons, where provisions of regulations are not rationally connected to the stated purpose of the provision and are therefore inconsistent with the purpose of the scheme. And we've set out 2 such cases at paragraph 65C of the amended Statement of Facts and Grounds. The reference is tab 30, page 303, paragraph 65C, no need to turn it up, there's no time in any event. They concern regulations imposing restrictions on access to legal aid, which the court determined were not rationally connected to the stated purpose of the provision, and therefore inconsistent with the purpose of the scheme. And I commend those to the court, and indeed we can provide electronic copies in due course, because it makes clear that these are just about legal provisions. There was no suggestion of quelling dissent. It was about lapsing. It couldn't be more mundane and straightforward than that. The simple issue is it rationally connected to the purposes of the law? The second point is the fact that Palestine Action meets the definition of terrorism, or the definition of terrorism, or the criteria for the prescription regime is no answer. It misses the target of the challenge. We take as a starting point for this ground that Palestine Action comes within all fours of the statutory definition. We're not asking the court to read down the language. We're not arguing with the purpose, for the purpose of this ground, that Palestine Action is not capable of falling within the provisions of the Act. We proceed on that assumption. Our argument is that the mere fact that the Secretary of State may rationally form a belief that an organisation satisfies the statutory definition for prescription does not in itself determine the question of proper purpose. Parliament is always intended to, always taken to have constrained conferred powers by reference to their purpose. And so, save in simpler cases where the purpose is provided for expressly, the starting point, like in the legal aid cases, is to identify the scope of the unstated purpose for which Parliament intended that the power should be used from a construction of the statute as a whole. A failure to state these purposes doesn't mean that the Act is supposed to apply without restriction, without any fetter on the executive. And we say that the purpose can be assessed, having regard to the statute as a whole, the extreme consequences of the prescription regime that cannot conceivably have been intended to apply in these circumstances, just having regard to how it's playing out and having regard to the other groups that have previously been prescribed. So they're my submissions on ground 1. On ground 7, there is no suggestion that the Secretary of State considered Palestinians, despite my Lord Lewis rightly considering that it was self-evident that she should have. Arab Christians are not Palestinian Christians.
But they are included. I mean,
they're included, but my Lord, in a measure that is about a group called Palestine Action that impacts particularly Palestinians, they cannot be subsumed. Their particular circumstances, the particular impact on them as a community, in circumstances where I would invite my Lord to consider the evidence of the Palestinian community that is before the court, where they say how sinister and alienating
if you've
it
taken
is.
us to that, or you've given us the references, the two witness statements, yes, we look at those.
Indeed, so it's not enough to say, well, it's obvious and it was subsumed. The impact on them as a group was not considered. It needed to have been identified, and it wasn't. And it's also the nature of the impact are very clear from the underlying evidence in Austin otherwise. And those are my submissions on this.
Thank you very much indeed. We're going to rise for 10 minutes and come back into court and tell you where we go next. Thank you very much indeed. 10 minutes. Thank you.
Live broadcast, so just better to know now. As soon as that goes off, yeah.
stuff.
Yeah, thank you. So they send us bundles for after the sign off, and then after the sign off, and just swap that KWP.
Can we just... Can you sort of... You might.
I think Johnson will not sit on this. Like, no, sorry. So the base. Maybe he'll want to see what happens too.
Yeah.
I'm feeling a bit under the weather, so
Okay, we'll talk.
thanks so much for today. Really lovely. Good luck.
I'm sorry you're not feeling well.
To the shoe.
They must give you like a.
I'll review the...
I mean, I'm sure if I had to do a button. Just get my mom to do it every time she comes from Canada. I'm not joking. Like all these saved up. Yeah. Things too, like hem my trousers.
What do they do on away? They do rock. Who's gone away? Yeah, they all go to France. Just repeat that again, Ben. Let me tell you.
Yeah. Stuff to induce.
Yeah.
I would come to Durban the local.
Just in, not but I think, do you object? I think that's what I said. I mean,
Normally I'm too hot in here, but
An issue of major constitutional
You sound more caffeine.
Would you be able to type down the you later?
yeah.
Family. Yeah, the when the thing happens next time.
Anything.
Yeah,
I think it's probably like pure.
Yes, I imagine that's so hard.
I was quite loud.
Modified by now. It'll be on Twitter.
Oh no, colleague. We've got. He's not been arranged yet.
I know that tomorrow's going to be good.
There is another terror list on Friday. On the 3rd. I have it for in about
Yeah, that's the start.
It's going to be quite kind of taking into account.
Imagine it's helped at home as well.
Disease is quite clear on that, isn't it? By the old wooden gate.
Yeah. No, Emily face inflated domestic hostility.
Even less.
But there's sugar ones keeping teenager.
20 years ago. 18 years as well.
I think he's used the
Yeah. Also.
some sort of.
You've got it now.
Agreement for future Western. Well, I've got a full list of the ones that you want to talk around.
Oh, it is.
Thank you all for waiting. Can we just raise a couple of points after indicating at the outset that we will be reserving our judgment on the appeal and our decision on the permission to appeal application. Obviously, we are acutely conscious of the hearing that has been fixed for the 25th to the 27th of November. We will do everything we can at an exceptionally busy time of the legal year to get our judgment or judgments out to you as quickly as we can. We hope very much we can do that in October. We will keep the parties informed. Please don't hesitate to make polite, constructive inquiries as to progress, should you need to. But we will let you know if things are going badly wrong in terms of timing our end. We do understand, as they say, the need for speed. Two ancillary matters of a different nature and magnitude, actually. The first is closed material. We had a lunchtime email from the special advocates. Has that reached you? No. Well, that's a shame. I'll ask my clerks to make sure that you get that. Could you let us know within 24 hours, 48 hours. Today is Thursday. Should we say 4 o'clock on Monday? What your position on that is and whether or not we can release the note into the open, either as we've received it.
The other side may want to make a comment on it.
Yes.
The opportunity to make a comment. So attorney Friday and then comments by Wednesday.
But not comments from the claimant. From
What,
Ammori.
if it becomes
Sorry,
an
forgive us.
If it becomes an open,
Yes, of course.
I think then
Yes. But let's take it in stages. First
Yeah.
of all, can we hear by 4 o'clock on Monday what your position on that note is? And I will make sure you get the communication from the special advocates. If something is going into open, of course, we will make any consequential directions for any comments from you, Mr. Hussain, and your team. Secondly, Mr. Hussain, you said orally that you would seek an indulgence and seek an extension of time. If it is your client's intention to stand by that request and it's something that you wish to pursue, then you need to do it properly. If you want to issue an application for an extension of time, then you should do so within short order and again by 4 o'clock on Monday. And Sir James, you will want to respond. It will need to be, as I say, a proper application supported by evidence in the normal way. And Sir James, I don't know how long you would want to respond. You haven't seen it yet, but perhaps by Friday of next week, 4 o'clock on Friday of next week, and then again something in response 48 hours after that for anything in writing. So James, I slightly bounced you into my analysis on Denton. Do you agree that this is not a relief from sanctions situation as opposed to an extension of time situation? Because if you wish to maintain the sanctions position, then please do. No, so it does seem to me this is an extension of time situation. Yes. Well, that's helpful. Could somebody please, perhaps all the parties together, draw up a draft order just setting out for the record these directions in relation to closed material and any application. I'm not ordering that you should make an application. Can I make that very clear? It's simply, if advised, we clearly haven't reached any decisions on the timing question, on the procedural question. We're just trying to manage things as fairly as we possibly can at this stage. I think that's everything. Is that everything? Well, Sir James, you started by welcoming us back. Some of us have never been away. Speak for yourself, as they say. But it is obvious how much work has gone into the papers, again, under short notice. It seems to be the hallmark of this particular piece of litigation for understandable reasons. Thank you all very much, front rows and second rows and third and fourth rows, for all the hard work and collaboration. Please continue that. I know that you will all be working hard towards November, and we will do whatever we can to make the preparation for that as constructive and unwasteful as we possibly can. Thank you also to the court staff for sitting on a long day today, as ever, even with the lights on now. We've been well looked after.
You put 5p in the meter, obviously.
Yeah. Thank you all. Thank you.
Yeah, I thought we did too.
Okay.